it seems as though it's going to open up, give a little bit of breathing room for the workers, which will supply all of you with more work here at the panel, but should give some brighter lines when these cases do go to trial, if they do go.
I find it very interesting that the statute pretty much puts the proverbial rabbit in the hat when they make a major life activity working and a substantial payment of working. So I'm going to be very curious as to how that particular element almost makes the statute limitless, I think, in its amendment, frankly.
I think that's always been there. I see it a little differently because I think it is a radical change to the way the courts have interpreted. The Supreme Court from Sutton to Toyota had really restricted the first level of analysis, which is the person who is suffering from a disability. Are they substantially limited in a major life activity? So it really takes away the barriers to bringing the case because it lists it broadens the type of activities in which you can be limited. It defines certain conditions which are almost by definition things that if you have a disability. It takes away the influence of mitigating factors, drugs and those things. So it's much easier for the plaintiff's lawyer to get through the door to make the case on the discrimination point. So you put aside California and New Jersey, where these cases have been going on, everywhere else in the country, now George can get to court. And I have said many times, because it's an area I've lectured on a lot, that these cases change for a defense lawyer when you're in court. You can, in the context of discovery, take on the issue, you're not really that seriously ill or you don't have that bad a condition. But when you have them up on a witness stand in front of the jury, you don't really want to be attacking them that way. And so I think it changes the whole nature of the defense, and then you're into a very kind of different area. So our strategy has been to get rid of these cases on summary judgment, and I think that's not going to be anywhere as easy.
Wayne, your commentary, and then you, Maria.
I think that another major component to this amendment is giving the EEOC the mandate to define the phrase, for example, substantially limits. I think we're going to, there's a lot of uncertainty there, but I think most likely what's going to happen is that phrase is going to be broadened. I think it's going to mean a much more difficult time for employers to achieve summary judgment in these cases.
Maria Petrillo.
I agree. Clearly, we're not going to be able to get summary judgment, but let's step back. How should we counsel our employer clients at this point? We have to talk to them about really integrating their policies on leave, on accommodation, and dealing with disability, and really, in essence, requiring this sort of integration between your risk management team, if you're large enough, your risk management team, your HR people, and your frontline managers. They need to understand the real exposure that they have if they're not attuned to people with disabilities, with clear problems, say diabetes, a cancer survivor or whatever, or someone who's struggling with other kinds of FMLA issues. The employer in 2009 and beyond who tries to integrate all of those things, disability leave, health management issues, as well as accommodation, will be much better off in the long run.
I agree with Maria. It's amazing to me, and maybe you guys don't see it with your well-informed clients, but it's amazing to me, and a very simple thing, with large corporations, how many cases I get every week where the HR person has checked off FMLA and not checked off the ADA liability. And I say this, it seems very obvious, but it happens over and over and over, and it just happened in a major case where the person saw that this was a key employee with a serious disability and said, no FMLA coverage. You know, and it happens over and over. And I say it, I mean, it may not be so exciting in a roundtable such as this, but for God's sake, you know, these people have to be advised by you employment lawyers not to simply look at so many of them immediately go to the FMLA and they never check for ADA leave accommodation, never.
And the larger portion of my cases really that I've had deal less with the, you know, you were fired because of, and more with the degree to which reasonable accommodation was afforded to the plaintiff. I mean, that has been more of the battleground for me and more than the type of case
And
that I've
that's almost a
handled.
throwback to yesteryear as well.